it would be in order to then advise him to withdraw the appeal and then reinstitute it with the correct grounds. That is, if the court perhaps does not use its inherent powers and permit him to argue that issue, despite it not having been raised in the notice of appeal.
Very well. Now, after you have had your exchanges with the unrepresented accused, he changes his mind, then he decides only to proceed with the appeal against sentence. But when you read the record that is before you from the court of first instance, it becomes clear to you that the accused was or could have been incorrectly convicted. Yes. How would you handle that situation?
Thank you, Commissioner. I would start off by referring to there is a matter of Hepworth. It speaks to the duties of a judicial officer in that you are not merely an umpire that is there to ensure that the rules are complied with and then it ends there. You are an administrator of justice. So it's fortunate that the High Court has inherent jurisdiction, unlimited jurisdiction, unlike the Magistrates Court. And in that instant, it's permissible to then not to allow him or to refuse the withdrawal because the interests of justice are dictating towards arguing the matter so as to ensure that justice is done. So I would then not allow the withdrawal considering what is prima facie from the record that perhaps he was incorrectly convicted.
Do you suggest that the High Court has inherent jurisdiction also to consider the conviction then under circumstances where it's only an appeal against sentence that is before you? Do I understand you correctly?
I would say yes. I would say yes because suppose this conviction is allowed to stand, there will be a traverse of justice. So I think the High Court that has got inherent jurisdiction, it can regulate its own proceedings, and where nothing is provided for, like in that instance, if the rules and or the law does not allow it to do so, I'm sure the High Court can assume the jurisdiction in that manner.
Okay. Can you just clarify, when you sit as a judge of appeal in this case and you have come to the conclusion that there is a problem also with conviction, procedurally speaking, what orders would you give at that stage in order to assist the accused as you said you would?
Maybe you can just come up with that question again, sorry.
Apologies.
May I get the question again?
When you now come to the realization, sitting as a judge of appeal, faced with only an appeal against sentence, when you come to the conclusion that there might be, that the conviction was incorrectly granted,
yes,
or incorrectly done, what would you do procedurally speaking to address that situation?
Perhaps it would be to bring it to the attention of the parties, because I can't go on a frolic of my own and then start arguing or making decisions on matters that would not have been argued before me. So I would perhaps bring it to the attention of the parties that I have identified this anomaly, and I'm seeking to have the parties argue it before me, saying that maybe there is just no way that a record would lie before me and it will relate to the merits of the case on which conviction would naturally have been followed. So I'm sure at that stage it should be an exception. So more so because it is in the interest of of justice. I'm sure even the prosecution would not have an issue with it, considering that they are not only there to secure convictions, but to ensure that justice prevails.
Very well. My second question is just also it relates more to a matter of procedure. I'm sure you are aware of Section 61 of the CPA, of the Criminal Procedure Act. Now, in circumstances where an accused person who is also incarcerated applies for bail when he is charged with one of the Schedule 2 offences, the court can, of course, if it deems it necessary, refuse bail if it is, and I stress the importance of the phrase, in the interest of the public or the administration of justice. Yes. That phrase is particularly included in that section. Now, that phrase, as you might be aware, is not defined in the Criminal Procedure Act. When an accused person appears before you, his legal representative informs you that they are of the view and that they hold instructions to launch an application to declare that particular portion of Section 61 unconstitutional, because in the absence of a definition, the phrase is rendered without full comprehension. Nobody can understand what the phrase actually means. Can you provide reasons and indicate whether or not you think such a challenge could succeed?
I see that one of the fish rot accused persons, as they are famously known, brought a challenge of that thought in the High Court. I don't know whether it is Hatwikulipi or Gustav. I think the full bench said, the majority decided that that section does not seek to violate the accused person's constitutional rights. It held that it is not couched in a wide manner so that it leaves room for ambiguity. In a bail application, we are there for bail, and then this application is brought. I'm not sure what counsel is really seeking now, whether it's to be heard on bail or is challenging the constitutionality of the section. Otherwise, I feel that debate has been settled.
Very well. If you are faced with this type of information that you receive from legal representatives that they want to bring a constitutional challenge in the middle, at the commencement or in the middle of a bail hearing, again, procedurally speaking, how would you address the situation going forward to ensure that the matter comes to finality?
I can't bar them onto how they want to, or which application they want to move. But then they should be very clear onto why we are there. Are we there for bail application, or perhaps they are challenging the constitutionality of that section? Because ultimately, if they are now bringing it in a bail application, I feel it might seek to prejudice some other interested persons. I'm sure the AG's office might have an interest in that. Now, if they are bringing it at that stage, I feel it would have been brought either in the wrong forum, or they would have misjoined or left out other parties that would have. So I would have difficulties to hear them.
Very well, thank you, Chief.
Thank you. There's a question from the Deputy Chief Justice here for you, Mr. Simasiku.
Thank you, CJ. Mrs. Simasiku, two things I need clarity from you. The first is that you have shown interest in the criminal stream. Now, once you are appointed, or if you are appointed, and the head of court decides to deploy you in the civil stream, will you be comfortable to work in the civil stream? Do you think you have the necessary experience to do so?
Thank you, DCJ. I was even wondering, when I came here, because I only got an invitation for the criminal stream. In my application, I had indicated though my strength is in the criminal law, I'm willing to jump into civil. I'm willing to learn. It's not as if civil, there's a perception that civil is difficult. But I think it's an issue of practice. We are not practicing it so much that we are used to it. So I'm available if so directed to try, and I can, if others have made it. I know of colleagues that were mostly on the criminal, they have now shifted to the civil. they are doing much better, so it could be an issue of willingness also on the part of the...
You're emphasizing willingness and availability. Can you talk to capabilities? Basic skills?
In terms of experience, civil-wise, for some reason, civil matters in the magistrates' courts are not moving. They don't see their day in courts. So much that in as much as we would have done the default judgments, summary judgments, executions, Section 65 inquiries, those we have done. But to be honest, I have only dealt with one civil trial from start to finality. So other than that, it is just this office-based work that does not take you to court. So it then became worse now that I got appointed to the regional court, because our jurisdiction is more on criminal. We don't get to preside over civil matters.
Yes. Thank you, Mr. Simasiku. Now, we were provided with the number of the party head cases that you have when we were given your nomination papers. Could you fill us in on the latest statistics as far as the party head cases that you have? And maybe coupled with that is, should you be appointed, how flexible are you to start in the High Court? And I'm saying that in relation to the number of cases that you may be presiding over at the moment. How much time would you require to complete those partly heard cases, if any? And I assume sitting in the regional court, faced with 700 odd cases, you must have picked up partly heard cases.
Thank you, Chief Justice. As at the time when I submitted my application, I think I was standing at plus or minus 30 partly heads. That was around September, October there. Unfortunately, I don't have the figures now of those that I have so far disposed of. This is so because a week before we were invited for the written test, my computer crashed, and then I had to send it to Windhoek for repairs. In fact, I had to borrow a colleague's a laptop for preparation of these interviews. So I did a rough count of what my memory could do, assist me with. It would appear I perhaps would have, between then and now, would have disposed of about 8. There is one that is pending mental evaluation. It was due for sentence, and then we realized that we raised the doubts into the mental capacity of the accused person in mitigation. So that one is also giving me headaches. Of course, in between there, I might have also picked some, maybe about 3 or 4, if I'm not mistaken, that I have added new partly heads. I must state that the reason why I have accumulated so many partly heads is these issues of circuit courts. Previously, you would sit at one place maybe for 2 weeks, then you move before you could finalize. There was no continuous role. Then you go to Utapi, you start, you can't just stay idle there, you have to start cases there. Then if there are excuses again, the witnesses did not come, they don't have money, then you have to start another one. So that's how we ended up finding ourselves in this situation. As far as the disposal plan is concerned, I'm sure if notice is given that the appointment will take effect in 3 months, with the willingness of the parties, knowing that I might not be available, we should be able to reduce these numbers significantly. It is also worth noting that maybe about 10 of them, they have not progressed that far. The strategy that we had was that we would allow to take plea at an early stage. So the difficult now is an accused person is just going to admit, for example, the domestic relationship. Now it becomes a partly head by virtue of that admission only. Right. So I think the majority of them, they have not advanced so much that even if I become unavailable, yes, the people would then be prejudiced. Very well. So I think the ones that are serious, we should be able to dispose of within 3 months. That is if the parties are willing.
Very well. Thank you, Mr. Simasiku. Now, are you on social media? But please don't specify which one.
Yes, Chief Justice.
Very well. Now, assuming now that you are appointed as a judge, one day you wake up, you see on your social media account, there is this scathing attack on your person from a member of the public. Something really said something bad, may I just use that simple language, about you. What would your approach be to such a scandalous attack on your person as a judicial officer?
Thank you, Chief Justice. I don't know whether you are making reference to the last year's utterances or publications that we might have seen on social media. It would depend to what extent. However, it is not up to the judicial officer to then take the debate. Particularly on social media, then you are fighting with this person. That would not be in order with the office of the judge and or judicial officer. The right thing, if at all one would want to take the person to the cleaners, would be to approach the courts so as to have the issue ventilated.
Right. Thank you. Now, as we are winding up, I think we have allocated you more time than we should. I think we've exceeded the time allocated to you, actually. Do you have any business interest that obviously you must have declared to the Magistrates Commission and which you think may have an impact on you as a judge, should you be appointed, or at the very least that you think that the Commission should know? Is there anything else that you would like the Commission to know? Something else that we have not asked you?
Unfortunately, none, Chief Justice. I'm not involved in any business activities.
Farming activities?
Farming, yes. One might have a few. It's tradition that you ought to have even a few. So there we are covered. Yes.
Or the commercial or subsistence level?
No, not yet, the Chief Justice. God willing, we get to that stage.
Yes. Okay. So anything else? There are no skeletons in the cupboard, Mr. Simasiku?
Not at all, Chief Justice.
We don't want to wake up one day after your appointment, should you be appointed, that something else, we read something somewhere and something that you did not disclose to the Commission, that would be a serious omission. So I'm giving you this opportunity to disclose anything else to the Commission that you think the Commission should know.
To my knowledge,
whether of a personal nature, a family nature.
To my knowledge, there is none, Chief Justice.
There's nothing. There's none.
Yes, Chief Justice.
Well, let's go then. You live in the northern, in one of the northern regions.
Yes, Chief Justice.
And obviously, should you be appointed, you'll have to relocate to Windhoek.
Yes.
It's just so that, as you know, just so that you know, the Commission does actually not provide housing. But what the Commission does is the government gives you a housing allowance that you can utilize to acquire a property of your own. I'm saying this because we have had instances where some demands were made on the Commission. And so we are telling you this up front so that you know, so that should you be appointed, you make the necessary preparations to acquire property of your own.
Thank you, Chief Justice.
Very well. On that score, then, I wish to thank you, Mr. Simasiku, for coming in, and good luck. You'll come to the end of the interview for you.
Thank you, Chief
You are
Justice.
excused.
Much appreciated for the opportunity. Wishing the commissioners all the best in their deliberations.
Thank you.
Thank you.
Next will be Mr. Nyazo, Mr. Victor Nyazo.
Good morning, Namibia. We are coming to you live from the Supreme Court of Namibia, where the Judicial Service Commission is conducting public interviews for the appointment of a new High Court judge. 5 senior magistrates have been shortlisted for the vacancy in the criminal stream of the High Court. These candidates, Marelize du Plessis, Elvis Mwiliima, Victor Nyazo, Makapa Simasiku, and Stanley Tembwe have progressed through a rigorous selection process and will face the final stage today. In fact, the interviews have already started with Makapa Simasiku already having
And who is
been
Victor Nyazo?
interviewed.
And what makes him tick?
Thank you, Chief Justice. Good morning, esteemed honorable commissioners. I am Victor Nyazo. I would say I grew up in the judiciary, particularly in the lower courts, having been appointed at the age of 23 years in the year 2009. I was fortunate enough that in my final year of pursuing my LLB degree, I joined the Aspirant Magistrates Training Program whilst finishing up my LLB. It was a bit demanding, but I conquered the challenge. Upon completion of my studies, I was then appointed as magistrate at the entry level, my first duty station being Rundu.
Which year was this?
That was in 2009. So I've been on the bench ever since then, and I've risen through the ranks in the lower courts. At the present moment, I hold the rank of Regional Court Magistrate. I'm stationed here in Windhoek at Mungunda Street. Academic-wise, my academic profile is I hold 2 Cambridge certificates, that is grade 12. I hold a certificate in corporate governance from UNISA. I hold a B.Juris degree from the University of Namibia. I hold an LLB degree from the University of Namibia as well, and a master's degree in criminal law and procedure from the University of South Africa. So overall, I've been a magistrate for the past 16 years and have served the country diligently and with competence in the execution of my duties. So in summary, that's Victor Nyazo, the professional.
Very well. Now, what competencies do you consider you would bring to the bench at the High Court should you be appointed, Mr. Nyazo?
Competence-wise, I would say I bring experience. Having been on the bench for the past 16 years, I believe I can contribute something meaningful to the jurisprudence of this republic, given the opportunity to do so at the High Court. I always ensure that in the execution or pursuance of my duties, I do so diligently and with competence, making sure that I research on what I'm doing. If it's a specific case, do diligent research and then write my judgment with sound reasons. So I believe I'm in a position to contribute significantly to the jurisprudence of our republic.
How many partly heard cases have you picked up to date?
To date, I'm standing at 22 part-head cases that I have picked up, mainly so because when you are seated in a trial court, it's inevitable that you'll pick up part-head cases because cases come on a daily basis, and the people want to be heard. They deserve justice. They want their day in court. So when you are seated in a trial court, it's unavoidable that you pick up so many cases.
How many are awaiting judgment?
One at the moment.
Is the judgment overdue or within the time frames provided for delivery?
I would say it's within time frame, because I think I reserved judgment, if memory serves me well. That was on the, I think, 28th of February, if I'm not mistaken, yes.
Thank you. DCJ, would you like to ask Mr. Nyazo some questions?
Thank you very much, CJ. I think the most important one is a follow-up to what the CJ has asked you. How do you deal with these 22 cases if you are appointed a judge next month?
Given the opportunity to ascend to the High Court, I would require a little bit of time. And in fact, already when I applied last year for this position, I devised a plan where I had started concentrating mainly on my partly head cases. And as we speak at the moment, the bulk of them are at the defense stage, and some, a few, one or two or three of them are at Section 174 applications, which the attorneys in the matter have decided to bring up. So I would say many of them are at an advanced stage, and
a little bit of time. Yeah. How much time is that?
In terms of time, I would, if I was to estimate, maybe 2 to 3 months, I should be done with all my part-head cases.
Well, the second one is, I assume you are familiar with the Section 302 jurisdiction of the High Court, the automatic reviews that come to the High Court.
Yeah.
Now, as a High Court judge, you are going to do a lot of that.
Yes.
Yes. Now, can you increase a sentence as a High Court judge if you are unhappy with the sentence imposed by the judge Akko?
Strictly speaking, in terms of the law, on review, a High Court judge does not have authority to increase a sentence on review, despite the fact that he or she might have different opinion or might hold different sentiment regarding the appropriateness of the sentence. What matters most is that the sentence should be competent. In other words, the sentence imposed by the magistrate should be within the jurisdiction accorded to a magistrate's court in terms of sentencing. As long as it's a competent sentence, the judge on appeal has no choice but just to confirm that sentence.
Is that the only solution you have? Can you, for example, not confirm, instead of increasing, say you refuse to confirm, and the PG does something about it?
On the judge's part, you are guided by the law, and if the law says if a sentence is competent, you have to confirm, and then you confirm. If the PG is unhappy, perhaps that's an alternative route available to the PG to perhaps maybe appeal the sentence that was handed down by the magistrate.
Attorney General. Thank you, Mr. Nyazo. In terms of our Constitution, Article 26 provides for the state of emergency that empowers the President to make certain regulations under the state of emergency. That will allow him to, when his opinion is for the protection of national security, public safety, and for the maintenance of law and order in your own opinion now, would that power also entail the President to suspend any laws or statutes or the rights and freedoms that are protected under our Constitution?
Just to see clarity, the question is whether if the power accorded to the state president in terms of Article 26 would empower the president to suspend fundamental rights.
Suspend either any laws or statutes or fundamental rights protected under the Constitution during the state of emergency.
Yes. My answer would be yes, as long as what's most important is it should be of general application, the suspension of those rights. And when the president does so, if my recollection serves me well of when I read that section sometime, it should be by way of gazette when the president announces that a state of emergency is now in force, and it should be of general application. And yes, some of the rights can be curtailed during that process.
Under which conditions can he do so? Or he do so? Or is it just a blank check that the president gets?
It's not a blank check. It will state in the gazette that is to be published specifically what rights are affected and to what extent those rights are affected, and the period within which the state of emergency will be in force.
Now, the concept of equality before the law is something that is also provided for under our Constitution, Article 10 of the Constitution. However, in our law now, can a sitting president be charged with a criminal offense or be subject to any criminal proceedings for either the act performed or the omission during his or tenure of office?
My answer to that would be a definite no. In terms of our Constitution, a sitting president cannot be charged for any criminal offense, and if I'm not wrong, in terms of also civil proceedings. Yes, the equality before the law states that everyone in the eyes of the law is equal, but that is an exception to the rule.
Why is that? Why would that be an exception?
It's an exception because a sitting head of state is the head of the country, and it would therefore be undesirable to have a head of state appearing in court, as that is scandalous, and it would not be good for the reputation of the Republic itself. Perhaps I'm thinking that is what the founding fathers who drafted the Constitution perhaps maybe were thinking of.
Are you then implying that the head of state may under no circumstances appear in court or before any court of law?
No. Perhaps it came out wrong. That's not what I'm implying. The head of state may appear in court, but not as an accused or as a defendant, from my understanding of what the Constitution provides.
Thank you. I will now invite Commissioner Shikongo to ask his questions.
Only last question. Are you aware of any jurisprudence in the Republic on that aspect of presidential immunity when it comes to criminal prosecution during his reign?
In this jurisdiction, I would say I haven't come across a case that speaks to that so far, unfortunately. And beyond as well, perhaps I would not want to distort facts, but I've seen it in our neighboring country with the former president Zuma having appeared in court in some instances, but I do not know on what merit, so I cannot say it with authority.
Of course, the Constitution is the guiding document the supreme law. So one has to familiarize themselves with the Constitution, what the Constitution says on that aspect. But Commissioner Shikongo, you may continue, please.
I'm sure if the guy has been over 16 years, you would have encountered the instance where the state is challenged with lack of evidence, or let's call it circumstantial evidence as opposed to direct evidence. How would you normally go about assessing that circumstantial evidence where the state cannot discharge honest with direct evidence?
There is ample authority from this jurisdiction on circumstantial evidence. The approach, in fact, the locus classicus on circumstantial evidence would be the Arves-Blom matter, where when you are confronted with a case, upon evaluating the evidence and you arrive at the conclusion that it's circumstantial evidence, you have to look at all the possibilities on the available evidence and exclude each and every possibility except for the one that will remain. And if the one that remains proves beyond a reasonable doubt that the accused person is guilty, then as a judicial officer you have to return a guilty verdict. It differs completely from the civil arena where the most likely possibility is the one that you can go with. But in criminal law, you have to exclude each and every little possibility that might be there. And the one that you are left with, if it points to the accused being guilty, you go with that. If it points to the accused being innocent, you acquit.
How do you reconcile it with the burden of proving the crime beyond any reasonable doubt?
Yes, the burden doesn't change at all because it remains with the prosecution. They are alleging that this particular person committed this crime, and therefore the burden remains with them. And as such, in the process of evaluating evidence, that's why you have to come to a finding that despite it being circumstantial evidence, you have excluded all the other inferences that could be drawn, save for the one that you arrived at, and that is beyond doubt the only inference that can be drawn.
Thank you, Mr. I believe you will agree that departure from mandatory sentence will be the exception to the rule.
Indeed.
Now, you will take into account circumstantial and compelling circumstances in departing, if at all you want to explore that avenue. How do you consider it?
I'll take a pragmatic approach to it. When I'm seated in court, say for instance it's a rape matter, and the accused person has been found guilty and is during pre-sentencing proceedings, the court is duty-bound, mostly where an accused is unrepresented, to bring it to the attention of that accused person, to say there are prescribed mandatory minimum sentence applicable in this particular instance. Be alive to that, and as a court, I expect you to inform me if there exist any reasons that is substantial and of course compelling for me to deviate from the prescribed minimum. I would want you to inform me of such so that I can record that. Now, after having been informed by the accused, obviously the prosecution will get an opportunity as well to present evidence, be it in rebuttal, whether if they are in concurrence with the accused that there exist or does not exist substantial or compelling circumstances. And when I sit to write my pronouncement on sentence, I would be guided by generally what has been presented before me by that particular accused person, be it his personal circumstances, be it conditions pertaining to maybe the manner in which the crime was committed, anything of significance that has been presented by the accused, and I would sit on that and then decide, is it deserving, does it meet the threshold as provided for in terms of the law, and also through guidance, through case precedent, on whether if I should depart from the prescribed minimum sentence. What I would be looking at is cases like Elvis Lopez and the famous Malgas case, which admonishes judicial officers not to lightly depart from imposing these minimum sentences, because they do serve a very important purpose. That is why the legislature saw it fit to have them enacted, and not just to have judicial officers exercising their discretion, which can only be retained if satisfied that indeed there exists substantial and compelling circumstances.
The key there is the notion of substantial and compelling circumstances.
Yes.
That is the key. So what is it that will constitute such?
Yes.
By way of example?
By way of example, as I was saying, it's a totality of everything that is. It's nothing unique or peculiar. Generally, it's what is being presented before you. You look at that collectively or cumulatively, and then you apply your mind to it, and then make a determination, of course guided by the law, whether if such constitutes substantial and compelling circumstances.
So you wouldn't say that there's no numerous clauses for those circumstances?
No, there isn't.
Thank you. Commissioner Campbell, then, please.
Good morning.
When you transition from the Magistrates Court to the High Court, you will find yourself often sitting as a judge of appeal in the High Court. When you sit as a judge of appeal against, in an appeal against sentence only, and on the day of the hearing, the unrepresented accused informs you that he wants to hand you documents to also appeal his conviction, not only his sentence, which is before you. How will you handle that situation?
Thank you. At that stage, I would say it would be, unfortunately for the unrepresented accused, be a situation of him bringing that to the attention of the court at the 11th hour. It's already too late, because he's bound by the papers that he filed with the court. So if he has had a change of mind in the interim or meanwhile, what I would advise the unrepresented accused would be to withdraw his appeal, go back, and then draft a fresh notice of appeal that would include an appeal against the conviction and not only the sentence, and then file it and institute the process from the start.
Very well. After you've explained that process or the available options to the accused person, he informs you that he elects only to proceed with his appeal against sentence. But when you read the court record from the court of first instance, in your mind, it appears to you that the conviction was incorrectly given. What would you do under those circumstances?
That's quite a unique scenario. Under those circumstances, if an accused insists that he would only want to proceed against the appeal against sentence, it's his prerogative to do so. However, I would try to impress upon him, because my sense of justice would not allow me to let it be. I would try to impress upon him that perhaps he should consider withdrawing the appeal and lodge a fresh a notice of appeal that would also attack the conviction. But to go further or beyond that, I believe would be descending into the arena, as it were.
Does the High Court have inherent jurisdiction to consider the
The High Court is a court of unlimited general jurisdiction. However, in this particular instance, what would come to mind is there is a specific issue outlined before court by a particular litigant, I would say the accused, and it is that he is only attacking the sentence. So, despite having that inherent jurisdiction, as a presiding officer, you cannot on your own now start inviting or bringing in issues which are not before you for consideration.
Very well. Are you familiar with Section 61 of the Criminal Procedure Act?
Indeed.
Section 61 deals with bail in the circumstances where the accused is charged with a Schedule 2, the more serious offences. Contained in that section are phrases, or one would find the phrase, in the interest of the public or the administration of justice. Can you explain to us what you understand under that particular phrase?
Thank you. In recent time, it was last year, I think, that was an issue of discourse in our courts in the matter of Ngipunya as the Minister of Justice. In fact, that judgment resulted in one dissenting judgment and one majority where, if I'm not wrong, it was Judge Masuku, who said that the definition of public interest and administration of justice is too broad and vague. There needs to be certainty as to what it entails exactly. And I think he went on further to recommend that perhaps maybe jurisdiction should look at what other jurisdictions are doing. If I recall, he mentioned Eswatini and I think other jurisdictions as well, where they have clearly defined what the concept of public interest means, or the interest of administration of justice. The majority judgment, on the other hand, was that the words public interest and administration of justice are couched in such a manner in the law itself, so much so that it allows the presiding officer to use his or her discretion, given the set of facts presented before that particular judicial officer, to make a determination whether, on the available facts, the interest of the administration of justice or public interest dictates that an accused person be admitted to bail or be denied bail.
Which view do you prefer, minority or majority?
To be quite honest, I'm with the minority.
You are with the minority?
Yeah.
Which one binds you?
I'm bound by the majority.
Now, can you briefly tell us what is the doctrine of precedent?
Doctrine of precedent, building on what I've just said now, and on your question, the last scenarios where still within the High Court, there is a judgment, you have conflicting judgments on a particular issue. Then you'll have a judgment where two judges sit versus a judgment where perhaps a single judge sat. The one where two judges sat carries more weight than the one where a single judge sat, and therefore, if I'm seated as a single judge, I'm bound to follow the judgment that was delivered, constituted by a full bench, as it were.
Does it mean if there was a single judge and you are also a single judge, you are not bound by a decision of your colleague?
You are. The exception would be if my colleague was completely or totally wrong on the law in that judgment. In that case, I would be justified not to follow that judgment.
Who determines whether your colleague was wrong or right?
The determination is just from my point of view, when the case is presented before me, and then I go through the case and then come to the realization that the application of the law in this particular case was not done in accordance with justice, or was not properly done, or my colleague Ed, in that way I would be justified to not follow.
What about the erratum on facts as opposed to just law?
Pardon me?
What about an error on facts as opposed to law?
Oh no, error on facts, that would not be a reason enough to not follow that decision. It has to be misapplication, or perhaps I would say gross misinterpretation of what the law is. One cannot easily, just at slightest whim, say, my colleague came to this decision, I will not follow. It has to be exceptional, if I can put it that way. For example, if the Criminal Procedure Act provides that an accused person should be accorded the opportunity to mitigate, and then in that particular case, the presiding officer decides when it comes to the mitigation pre-sentencing phase, 274 of the CPA gives or empowers either party, prosecution or accused, the opportunity to mitigate. So if in that particular case a judge comes to a decision that no, in this particular instance you are not allowed to mitigate, if I'm presented with a case precedent of that nature, surely that would be totally wrong, and I would not be justified to follow that.
Very well. So, finally, Mr. Nyazo, is there anything else that you would like the Commission to know, something that you consider to be important, that you can't leave this venue without informing the Commission?
Perhaps maybe I can say I was also caught by surprise in recent time when I read an article in the newspaper to the effect that a complaint had been laid against me with the JSC, the Magistrates Commission, and the Ombudsman by an accused in a particular case that I had dealt with. All that I can say to that is, as a judicial officer, I'm required to decide matters. I applied my mind in the particular matter and decided the facts, on the facts, presented before me, and arrived at a decision. And the complainant in that matter perhaps was aggrieved and did exercise his right to appeal. And of course, on appeal, the High Court, on the available evidence, came to a different conclusion. And in that judgment, if one would take time to read that judgment, nowhere did the High Court say that I was biased in my adjudication of the matter, or that I was incompetent. In fact, to the contrary, the judge commented that the magistrate had meticulously addressed or evaluated the evidence. That's what I would like to say, or set the record straight. Thank you.
Thank you for pointing that one out. I expected you to point it out, yes. And any other disclosure, any financial interest that you may have elsewhere that may impact on your work as a judicial officer at the High Court level, or at any rate that you think the Commission should nevertheless know?
Frankly, no, Chief Justice.
You are not involved in commercial enterprises like businesses? Commercial?
No, not business.
Farming? What about farming? Are you covered also?
No, I'm still trying to work my way up to there. Yes, but
farming is not business.
Yeah. Very well. Thank you so much for coming, Mr. Yes, I'm reminded of a very important thing. It may seem innocuous, but it's important. And that is to say that should you be appointed, please do not have any expectation to be provided with housing from the Commission side, or the Office of the Judiciary side. That's really a facility that we do not have as a Commission. But as you know, government provides a judge with an allowance to purchase property of his or her own. And that is really the facility that one should make use of should one get the nod to get appointed. It's just a formality that I thought we should let you know.
Thank you.
Because of the past experiences that the Commission has had on that aspect.
Thank you, Chief Justice.
Other than that, I wish you all the best with the outcome of the interview, and thank you for coming.
Thank you, Chief Justice, for the opportunity. I must say it was intellectually stimulating, starting from the first round up to this round. Thank you very much.
Thank you. Good luck. We resume at 11:15. Okay. We will adjourn.
One, two. 1, 2. Yes, 1, 2. Testing. 1, 2, 2, 2, 2, 2, 2. Testing. Yeah. 1, 2. 1, 2, 1, 2. Test. 1, 2, 1, 2. 1, 2. Also fine. 1, 2. Yeah, also fine. 1, 2. Also fine. 1, 2, 1, 2, 1, 2. We have only 3 mics. This, that, and the other one.
Right, let's resume with our proceedings. Next to appear before the Commission will be Ms. Marelize du Plessis. Ms. du Plessis, please. Welcome, Ms. du Plessis.
Thank you.
As you know, you have been nominated for possible appointment as a judge of the High Court, and we were advised that you are specifically nominated for the criminal stream. But just as for us to be clear, is that nomination for a criminal stream cast in stone, or you are amenable also to being assigned work in the civil stream?
I would absolutely love to also work in the civil stream. However, given the nature of the lower courts at this stage, it will be a learning curve again. Because in the regional court we deal exclusively with criminal law.
Right.
However, when I did do civil law many moons ago when I was still in the district court, I did enjoy it, and yes, I would appreciate such an opportunity as well.
Very well, very well. Now, Ms. du Plessis, could you introduce yourself to the commissioners and to the country, the nation at large? Who is Marelize du Plessis?
Thank you. Yes, I was born in Namibia in Windhoek, 1972. My parents moved out of Namibia. If I could, I would have stayed. With the result that I grew up in South Africa in the Western Cape in Worcester. I completed my secondary education there. I attended the University of Stellenbosch, where I obtained my BA LLB degree. I then did my articles in a little town called Ceres, where the fruit juice comes from. I practiced there after I completed my articles for another 5 years. My husband then got a position with his company in Windhoek, and of course I grabbed the opportunity to return to my motherland. I then applied with the magistracy in 2000, and I have been in civil service or in the public service since then.
You are now at the level of the regional court.
Of the regional court.
And where are you based? Which town?
Otjiwarongo.
Otjiwarongo, region.
That's correct.
Right. Since when have you been serving as a regional court magistrate?
It's been now for the last 8 years.
8 years?
Yes. Before that, I was the divisional magistrate, and I also filled in quite regularly when the late Mrs. Diergaard could not attend to cases.
Right. Do you now think that you are in a position in which you could make a transition from the regional court magistrate, possibly to the High Court?
Yes.
And what are those qualities that you believe you possess that would make you go through that transition and ultimately being appointed as a judge of the High Court?
I do feel I am at a time in my life, my personal life, my professional life, where it is time to make a transition. Being too comfortable in one spot is never good for personal development. It would be a challenge, but it is one that I feel that I am ready for. I only have one child. She's busy with her last year in school. So I feel the time is right to make the transition.
What is the number of the cases that you are handling at the moment in the regional court? Approximately how many you are in a position to tell us?
Yes, it's about 80. I do Otjiwarongo, and then also once a month I attend to Grootfontein as well. Partly it.
Partly head.
Partly it. Oh, sorry, I misunderstood. My apologies.
Yes.
I think it's 4 in Grootfontein and 14 in Otjiwarongo.
So in total you are doing 80 cases?
Yes.
But not all those 80 cases are partly heard?
No, only those, it's 18 that are partly heard, but of those, 7 are for judgment.
7 are for judgment?
Yes.
Why is 7 for judgment? And is there any particular reason why you accumulated 7 cases for judgment?
No, I do not. I can understand where your question does come from, but no, I do not sit on judgments. It's just mere coincidence. It's that there are now so many.
Very well. Now, should you be appointed, how quicker or soon are you able to take up the appointment, given the number of the cases that you are presiding over at the moment?
June.
So you are confident that you'll be able to finalize all those 14 cases?
I have looked at my roll,
time?
at my diary, and I have not placed, as far as I can recall, I did not place any cases that are partly heard beyond May.
Very well. Now I would like to give an opportunity to the commissioners to ask you questions and to have an interaction with you. If I may start with the Deputy Chief Justice, please.
Before I ask the matters of substance I want to deal with, I just want to latch on to the discussion the CJ started with you. In the regional court, what is the highest sentence you have imposed?
20 years.
20 years. And what sort of matter was that?
It was a very serious rape. The complainant sustained multiple knife wounds. She was kept for 2 days, and she was also raped multiple times.
All these things, of course, get appealed. Was it appealed?
Yes.
And what happened?
It was confirmed.
It was confirmed. Thank you. Can you explain to us the principles that govern recusal applications?
I think the first thing to say there is the old adage that justice must not only be done, but it must be seen to be done. In other words, as soon as there is a perception of bias from the party requesting the recusal, whether that perception may be reasonable or not, the magistrate or the presiding officer, whatever the case may be, should consider the reasonableness or not, or whether such a perception of bias might exist in the mind of the party bringing the application. And if it does, then, in my opinion, what I have always followed is better to err on the side of caution if there is an application for recusal. So I would, if there is a perception of bias, I would recuse myself.
Now, recently in Botswana, 3 judges of the High Court felt that the Court of Appeal there, that is the highest court in Botswana, breach the Constitution and set aside the judgment of the Court of Appeal. They said the judges of the Court of Appeal violated the Constitution. You want to say something about that and locate it in the principles of the Precedent? Started decisions?
Who set it aside?
The High Court. For example, the High Court judges in Namibia, 3 judges sit here and say
the Supreme Court
got it wrong. We are setting it aside.
Yes, that's one for the books.
Sorry?
So that's one for the books.
I see.
Yes, of course the Supreme Court, if I transpose it to Namibia, is created by our Constitution's Article 78. It has inherent jurisdiction. It has been said that the High Court in Namibia has original jurisdiction. It is both a court of first instance as well as a court of appeal. But according to the Constitution, the Supreme Court is the highest court in the country, and in my opinion, it would not be correct for the High Court to set aside a decision of the Supreme Court based on unconstitutionality.
How can a decision of the Supreme Court be set aside under our Constitution?
According to my knowledge, it's been done once in the Lekunwe case. It is in terms of Article 81 of the Constitution, which reads that the Supreme Court can set aside its own decision, or a decision of the Supreme Court can also be set aside by an Act of Parliament.
So an Act of Parliament can set aside a decision of the Supreme Court?
According to the Constitution.
In what circumstances?
One doesn't come to mind. I am not, to my knowledge, aware that it has been done.
So Parliament can simply just pass a law and say we are setting aside the decision of the Supreme Court?
According to Article 25 of the Constitution, it is the duty of our courts to uphold, of all the courts to uphold the Constitution. It is, however, not only the duty of the judiciary. Article 25 makes provision that it is also the duty of both the executive and the legislature. So the legislature, in terms of Article 25, would also be bound by the principles as set out in the Constitution.
You're familiar with Article 81 that says that such an Act of Parliament must be lawfully enacted.
Of course.
Yes. But just to add to the question posed by the Deputy Chief Justice regarding a case in a neighboring country, just to say that the highest court in that country also set aside ultimately the decision of the High Court. So that decision is no longer on the. It's not part of their jurisprudence. Mm-hmm. Yeah. Now, I would like to invite the Honourable Attorney General also to pose questions.
Thank you, Chair. Morning.
Good morning, sir.
Mr. Plessis, in terms of Article 31 of our Constitution, the state president enjoys certain immunities from civil and criminal proceedings. Under which circumstances does the president enjoy those immunities?
It is not something that I gave much attention to when I prepared, I must admit. I would assume in the lawful execution of his official duties.
Will that be then while he's still, or she's still in office, or after leaving office, or?
Well, I cannot imagine that such immunity would extend beyond the term of office.
Now, there is certain provisions within our constitutions that provides some extraordinary powers to the state president during the state of emergency. For example, Article 26 provides that during the state of emergency, the state president shall be entitled by regulations to make, or no, by proclamation, to make regulations that, in his opinion, are justifiable for the protection of state security, maintenance of public order, etc., etc. In your own understanding, would the state president be entitled to also suspend any law, be it statute or common law, or suspend the rights and freedoms that are protected in terms of our constitution?
Yes. If I can take an example, the right to freedom was curtailed, which is contained in Article 7 of the Constitution. The freedom of movement, if under the pandemic that we just experienced, that right was indeed curtailed through the proclamations that instituted a curfew, limiting the population's right of movement. But of course, it was in the circumstances as was contemplated in your question. I've also seen that although nobody can be forced to work, forced labor, if it is in the interest of state security for people to perform labor in the interest of the country, then even that will be lawful.
The right of the accused to be brought to court within 48 hours? Can the president suspend?
It is always a balancing act, as is much with the work that we do. It is the right and the right of the accused to be brought before court within 48 hours of his arrest. That is his individual right, but that of course must always be balanced against the interest of the community as a whole.
Would you then say that those powers that are given to the president, are they subject to some limitations, or they are basically just open?
No power under our Constitution is absolute. It is the exact purpose of the Constitution, excuse me, to rein in the abuse of power, especially by the legislature or the executive. So all decisions, Article 18 of the Constitution deals with administrative justice, which also squarely brings that within the principles of legality and the rule of law, that everything that is done in our country must be looked at as was said through the prism of the Constitution. In other words, if any party approaches a competent court in terms of section Article 25, our courts will be able to rein in any such unbridled exercise of power.
Commissioner Shkiko, would you like to come in?
Good morning, sir.
We've had several cases dealing with circumstantial evidence. Recently, Supreme Court and in the High Court, quite high-profile ones, also in your forum at the level of Magistrate Court and also High Court.
Yes.
And there's been judicial pronouncements on those. Could you just share with us, pick any one of those and share your insight into how the court dealt with the issue of circumstantial evidence and whether you agreed with the approach taken?
Yes. Excuse me, sorry, I've got bronchitis. Yes, the test, of course, is State versus Blom. Whether the inference a court wishes to draw is in alignment with the proven facts, and if that is the only reasonable inference that can be drawn from the proven facts. So that is always the benchmark that you move from. Sorry. No, it's mine. Thank you. I think what is very important to understand is that circumstantial evidence is not necessarily weaker than direct evidence. What I always feel is that circumstantial evidence cannot lie. It is not a witness that forgets. It is not a family member who gives biased evidence. It is simply that fact was proven, and from that you can, with reasonable certainty, infer that this occurred. So it takes, to some extent, it takes away the human element of direct evidence. Yes, I don't know whether you want me to elaborate any further.
Serve to assist the state in discharging its burden. Would you say, is that what it does?
Definitely. There's I think equal weight should be attached to circumstantial evidence as is done to direct evidence. Yes. And following that, then even if the state's case is only based on circumstantial evidence.
How do you balance it against the state's obligation to prove its case beyond any reasonable doubt in criminal matters?
I think that is where the second leg of the Blom test comes in. It must be the only reasonable inference that the court can draw from the proven facts.
Compelling and substantive evidence is one of those triggers that one takes into account when we have to depart from a mandatory sentence. What is it that constitutes in the adjudication of facts or circumstances before yourself? What is it that constitutes compelling it and substantial circumstances?
Yes, I think the cases that comes to mind in that regard is that of Malgas and Lopez, the Namibian case of Lopez. I always feel that circumstantial and compelling circumstances, it's not something special or extraordinary. It has been decided by our courts many times that all the usual circumstances that the court does take into account, specifically regarding the personal circumstances of an accused, the cumulative effect of those personal circumstances combined can constitute a substantial and compelling circumstance. The court should, however, be careful not to deviate from a minimum sentence for flimsy reasons or because it has sympathy for an accused who has to go to prison for his first offence, or even in some instances where it might be that the presiding officer is not in agreement with the policy created by the legislature through the institution of mandatory sentences.
If it's not something special in terms of what we have to look at, would you say it's an objective standard that is being applied here in taking those circumstances into account? Or does subjectivity plays any role?
I don't know. Objectively speaking, if you have an accused that I do not want to use, but that ticks all the boxes, that is useful, it's a first offender who maybe has 1 or 2 children, who has remorse for what he has done, who has maybe spent 5 years in custody already, then objectively speaking, from the court's point of view, the cumulative effect of those circumstances, in my opinion, would be a substantial and compelling circumstance.
By now you would have presided over several Section 174 applications. What are those considerations that you take into account when adjudicating 174 applications?
I actually phoned a colleague of mine and I asked him, I am very confused by the case law at the moment. Does the second leg of the shipping test still stand? And his answer was, it depends who you ask. But yes, the shipping test is still the benchmark, in that is the evidence upon which a reasonable court, as was said in the Teka Nakali cases, acting carefully, will convict the accused. And then also, is there a chance that the accused might supplement the state's case? I am of the opinion that if the state's case is weak, there should be no duty on an accused to come and testify in his defense to supplement, or in the hope that he will supplement the state's case. I do feel that it would be contrary to Article 12 of the Constitution, in that it places a duty on the accused to incriminate himself. So yes, there's also other considerations where, for instance, it's been decided many times that the court should look at the totality of the evidence that has been presented to it. In the Simon and Van Rijn cases, the court went so far as to say that the plea explanation that the accused has given in terms of Section 115, where he maybe discloses, or what mostly happens is that he discloses a defense of private defense many times in quite detail, then that in fact places a duty of rebuttal on the state to negative such a defense, and that the court, when considering a Section 174 application, is in fact allowed to view the plea explanation as part of the evidentiary material before it. If, for instance, as happened in the Van Rijn case, the state witnesses themselves in effect corroborate the plea explanation of the accused, then the court in such instances is in fact allowed to grant a Section 174 application, even though the state will then not have an opportunity to cross-examine an accused on his defense of private defense.
Does the test relate to what the court might convict on or could have convicted on?
Could.
Very well. Now, I would like to invite Commissioner Kamba
Thank you,
pose
Chief
the questions, please.
Thank you, Chief Justice. Mr. Plessis, I take you back to the question that was asked by the Honourable Attorney General regarding the limitation of certain rights and freedoms as contained in Chapter 3 of the Namibian Constitution. In your view, are there any of those rights or freedoms that are absolute, that can under no circumstances whatsoever be limited or suspended, even in a state of emergency?
The right to life, I would assume.
Anything else?
I can think of instances where the other rights might possibly be limited. So, yes.
What is your understanding between the fundamental or the main differences between appeal and review proceedings?
The court who sits as a court of appeal, the High Court, as it relates to the lower court cases, has the same powers as are granted in Section 304 of review. However, so those are the same. However, a court of appeal does have greater powers than sorry, this microphone is making funny noises. Thank you. For instance, I think that was also a question in the test. There is case law saying, and I agree with that a court on review cannot increase a sentence. It is not mandated by the wording of Section 304. However, a court sitting as a court on appeal, court of appeal, under the circumstances mandated where the sentence induces a sense of shock or is startlingly inappropriate, then a court of appeal would be able to increase the sentence. So the purview of an appeal court, in my opinion, is then greater than that of a review court, but it includes everything that a review court can do.
Well, if you sit as a judge of appeal in an appeal against sentence only, and it appears to you from the record of the lower court that the conviction itself may have been incorrectly given, how would you address that situation?
Yes, the court is only allowed is maybe the wrong word, is supposed to look at the specific grounds of appeal. In other words, if the ground or the appeal is only against the sentence, that forms the only ground of appeal. But when going, then the court is only supposed to look at that. However, Section 16 of the High Court Act does give review powers to the High Court, which includes, for instance, I think there are 4 grounds where there's malice or bias on the part of the magistrate, or where inadmissible evidence was allowed, and also where a gross irregularity took place. And I would feel that if you realize through looking at the record that the conviction is in fact not in order, that would constitute a gross irregularity that can be cured through the use of those powers.
It is so that the High Court has review powers to correct irregularities in the proceedings. The words "in the proceedings" does that mean it is irregularities that occurred in court only, or could it also be irregularities outside court?
I think it can be conducted outside of court, and I think the test should just remain the same, whether the irregularity is of such a nature that it renders the trial so unfair, so as to say that no trial in effect took place.
Very well. Just one last question. You spoke about the inherent or the original jurisdiction of the Supreme Court and the High Courts. Does the High Court have inherent jurisdiction to consider the conviction in the case where only sentence is appealed?
Where only sentence is appealed? Yes, yes, it does.
Thank you, Ms. Du Plessis. Now, you're on social media.
Yes.
Yeah, don't specify, please. Don't advertise anything, anybody, anything here. So, but what is your... Do you have people who befriend you on social media, who follow you?
I only befriend people that I know. I'm on social media to know when the next farmers market is. Things like that. So yes, old school.
Yes. So, but what is your take generally about the judicial officers' active participation on social media?
Like I say, I use it for informative purposes. I think one should be incredibly careful to post or share.
What if you were to discover that somebody posted negative comments about your person, about the way you have handled the case? How would you approach that posting?
I think what our mothers taught us, silence is golden. You do not respond at all. That, according to me, would be the safest way. You, of course, never have control over what other people say, and I think that is the inherent danger of social media. But, of course, if it crosses a border of becoming contemptuous, then steps should be taken.
Steps. But you take it also that there must be other institutions that should come to the defense of the judicial officers.
I do not think that the judiciary should be defended in the muddy waters of social media. I think the rules are in place. I think there's a great vacuum regarding cyberbullying, sexual harassment. I think our legislature has a long way, and it must do it fast to fill those gaps regarding our social media and our children.
Is there anything else that you'd like the Commission to know? Something that we have not asked you, but you think it's important that we should know about?
I can just say that I thank you for the opportunity, and I hope my passion for the law shows. Because
are there any complaints lodged against you at the Magistrates Commission against maybe an accused who is aggrieved by the decision that you took, a member of the public? No. To date, nothing of that sort has occurred.
Yes.
Right. You are based in Oshuarongo, you said?
Yes.
Well, of course, should you be appointed, I would like to inform you on behalf of the Commission that the Commission is not in a position to provide housing to you, should you relocate to Windhoek. Mm-hmm. However, as you know, there is a provision in the conditions of service of judges that you're provided with an allowance which would enable you to purchase property of your own, which you can then use as your residence. So that's a provision that we must all take advantage of and actually do precisely that.
Yes, I understand.
But if you were to knock at the Commission's door and said you recommended for my appointment and now you must provide me with a certain house in a certain location.
Yeah, it's just my husband and I.
Bad news is that that's not possible from our side.
Yeah.
Right.
Okay.
I just wanted to be clear about that.
Okay, thank you.
But otherwise, I would like to thank you on behalf of my colleagues, the commissioners, for coming to interact with us. And so I wish you good luck with the outcome of this process.
Thank you so much, and you must all have a good day. Thank you for the opportunity.
see. Next on the line is Mr. Tembwe, Mr. Stanley Tembwe. Mr. Tembwe, welcome. You have been nominated for possible appointment as a judge of the High Court, specifically in the criminal stream. But do you feel bound by that nomination that you must always serve in the criminal stream? Or are you flexible? Are you amenable to being appointed in the civil stream as well?
Good morning, Chief Justice. I'm amenable to serve also in the civil stream.
Do you have some experience in a civil court, serving in a civil court?
I only have experience in the civil stream of the lower court, but not necessarily of the High Court.
Yes, very well. But before we go any further, the Commissioner would like to know who Mr. Tembwe is. Would you please introduce yourself to the Commissioners and to the nation at large, Mr. Tembwe?
Thank you, Chief Justice. My full name is Stanley Mwiliima Tembwe. I was born at a village called Skanjavuka in Zambezi region, the former Kaprivi region. And I hold a B.Juris degree from the University of Namibia. And I also hold a Bachelor of Laws degree from Cavendish University in Zambia. And my judicial career started in 2007, where I was appointed as a magistrate in Ucho. And then thereafter, in 2009, I was promoted to senior magistrate, moved to Chivarongo. And then thereafter, I became principal magistrate in Grootfontein, and then eventually, now I am a divisional magistrate based in Keetmanshoop, where I'm the administrative head for Keetmanshoop division. And being a divisional magistrate, I'm also actively presiding in the regional court. And briefly, in the lower court, I have a combined experience of 17 years and 8 months.
I'm pleased to hear, Mr. Tembwe, that you preside over criminal cases in your division, because that's important. I think that's actually the latest development. Previously, divisional magistrates used to do mostly administrative work. Am I correct in that?
You are correct, Chief Justice. I had to step in the regional court because the volume of work cannot be done by one magistrate who is appointed for the regional court. The entire division only has one regional court magistrate, and the stations were just a lot for the regional court magistrate to handle alone.
How many cases have you accumulated so far? First of all, the total number of the cases that you are presiding over in the regional court. If you can break that number into the partly heard cases. And then amongst partly heard cases also, how many are waiting for judgment?
The partly heard cases, Chief Justice, that I have currently, that are active on the court rolls, excluding those where accused are on warrant of arrest, there are 6.
Only 6.
And out of the 6, I do not have any judgment that is pending.
So if you were to be appointed soon, anytime soon, so you are flexible, you'll be in a position to transition to the new posting?
I'm flexible, Chief Justice.
You don't have any other maybe administrative work that is pending or outstanding that may affect that transition?
Not that I'm aware of. What usually happens in situations like that, if someone maybe gets appointed, the office usually ensures that there is someone who acts in your position if you are given an acting stint or if you are permanent. There's always some transition that the office takes care of. But like I said, my party heads are 6, and most of them they are at an advanced stage. And they have not been delayed by myself. It has been some chain of other factors that has contributed to the delays. But I'm in control over those matters.
How many regional court magistrates are there in your division?
There's one regional court magistrate.
And what is the volume of work like?
The volume of work, it's not so huge. The whole division has less than 210 cases, but it's just sporadically spread in Cape Manshope, in Mariental, and in Karasberg, and also at the coastal towns of Fluderit.
Now to invite the other commissioners to ask questions, if any. But before I do that, because I'll give the Attorney General a chance to ask you a follow-up question.
Yes, a follow-up question. Thank you, CJ. Just to understand, since you are primarily responsible for administration in the division, how many percent of your time would you say you spend doing administrative work, and vis-a-vis that, how many percent of your time you spend doing court work?
Thank you, Commissioner. The regional court, I'm attending to it for a period of 1 week in a month, because I'm now presiding in the regional court in Luderitz and in Oranjemund. So the sitting of those courts, it's only 1 week in a month. And then the 3 weeks, then I'm on the administration. So there is a court program that is designed to that effect. So there is 1 week in the regional court and then 3 weeks on the administration.
Thank you, CJ. Mr. Tembwe, as a High Court judge, in what sort of circumstances is a judge of the High Court, may a judge of the High Court depart from or is not bound by a judgment, a previous judgment of another judge of the High Court?
Thank you. Thank you. A judge of the High Court is not bound by a decision of another judge if the previous decision was erroneously arrived at. And there are numerous judgments where the High Court has distanced itself from the previous judgments that has been delivered in the same court. For instance, there's this matter involving it's a drug-related matter involving Proclamation 277 of 1977, where metacolone was previously categorized under Part 2 of the regulation. And the previous judgments placed metacolone under Part 2 of the proclamation, whereby metacolone was considered to be a potentially dangerous dependence-producing drug. And there was a judgment of the High Court whereby they distanced themselves from the previous interpretation that existed. And the correct view was now that metacolon falls under Part 1, and it's categorized as a dependence-producing drug and not necessarily potentially dangerous dependence-producing drug. So it was remarked in that judgment clearly that the High Court was not, in fact, they indicated clearly that the previous judgments were wrong, and the judgment that they held in that matter was the correct one, which was to be followed.
Okay. From the first day, probably, that you are going to become a judge, you are going to face recusal obligations. They are very popular these days in our courts. What is the test that you apply to adjudicate the recusal application?
The test for recusal, firstly, there's a presumption that a judicial officer is impartial when adjudicating on a matter and is only subject to the Constitution and the law. Then there is also some consideration that has to be made. There is some principles that were extensively discussed in the matter of. I'll start with the matter of Bennett versus Absa Bank. It's a South African judgment where they discussed the test of recusal. In that judgment, it is said that recusal. I mean, a judicial officer can recuse himself or herself on a matter if there are some utterances that he has made during the proceedings, whereby if those utterances are made, they create a reasonable apprehension of bias in the mind of in the mind of a litigant. So, in the Louis January matter, Louis January versus the Master of the High Court, there is also what is called the double reasonableness test. The double reasonableness test entails that, firstly, there has to be a reasonable apprehension of bias in the mind of a litigant before a judicial officer decides to recuse himself. And then the second leg is that the basis upon which the recusal is premised must also be reasonable. And then that was the principle that was mentioned in the matter of Louis January versus the Master of the High Court. In that matter, they also confirmed the recusal principles that were discussed in a constitutional case emanating from South Africa, the Sarfu and others versus the President of the Republic of South Africa and others. So I think in that judgment from South Africa, they extensively also discussed the double reasonableness test on recusal applications. So generally, a judge is not to recuse himself from a matter just lightly. There has to be cogent reasons and before one decides to recuse himself or herself from a matter. On recusal also, there was also a matter that emanated from our jurisdiction here. It went up to the Supreme Court, where a group of magistrates who were acting in the regional court were eventually not appointed in those positions, and then they decided to abandon work in the regional court on the premise that they were not eligible for permanent appointment. In the High Court, the High Court ruled that the magistrates correctly recused themselves, but when the matter went to the Supreme Court, the decision of the High Court was reversed. The basis was that there was no cogent reasons for those magistrates to recuse themselves from the said matters.
Thank you. AG.
Thank you.
Because you asked the first one, I thought you
Mr. Tembwe, I want to bring you to the Constitution, our own Constitution, Article 10(1), that provides that all persons shall be equal before the law. However, Article 31, in terms of Article 31, the State President enjoys immunity from civil and criminal proceedings. Now, under which circumstances can a State President be sued in civil proceedings, and under which circumstances can a State President be charged with criminal offenses?
Thank you, Commissioner. A president can only be sued if he is no longer sitting as a president in terms of our Constitution. To be sued.
The AG has in mind murder, for example. You are talking about suit.
Or suing, to be sued in a civil proceeding.
No. The other. AG mentioned criminal.
Criminal, what about criminal? It was the possession there.
Under what circumstances can a president be?
Yeah, let's put it this way. Let's start with the civil proceedings. Under which circumstances can he be sued? He or she be sued in civil proceedings?
In civil proceedings, if in circumstances where the president is alleged to have breached some parts of the law.
That official capacity, personal capacity?
In the official capacity, but not in the personal capacity.
Presidents are always accused of breaking laws.
But usually they are sued in their official capacity.
So in official capacity?
Yes, Commissioner.
If there are some proceedings in his personal capacity, can he be sued while in office?
Not while he is still sitting as a president.
And in terms of the criminal proceedings, what is the situation?
I think the immunity also applies in criminal proceedings. If he's still sitting as a president, he cannot be charged.
Good. Now, during COVID time, I'm sure you are aware that the country was placed under a state of emergency, and that was done in terms of Article 26 of the Constitution that also empowers the President to make regulations that he or she deem necessary for the protection of national security, maintenance of law and order, and public safety. Under those circumstances, can the President suspend common law, statute law, or any rights or freedoms that are protected in terms of the Constitution? So, under which conditions?
Just repeat once more, Commissioner.
Yes. Just think about COVID time.
Yes.
The country was under state of emergency. And under Article 26 of the Constitution, the President is empowered to make regulations that he or he deemed necessary for the protection of national security or maintenance of law and order or public safety. Now, since the President is given so much power during the state of emergency, is he also entitled to suspend certain laws, be it statute or common law, or to suspend the rights and freedoms that are provided for under the Constitution?
Thank you, Commissioner. My answer is yes, he is allowed to do so. If I recall well, during the COVID period, the right to movement, free movement of people was also curtailed. It was done so because it was in the best interest of the people of the country that movements were curtailed in order to contain the situation that was there at the time. But I can also mention that curtailing those rights that are enshrined in the Constitution has to be justified. The President cannot just or should not just curtail those rights as it pleases him, because those rights are not supposed to be derogated from, lightly.
Are there any limitations in your understanding to the exercise of such power, whether in terms of conditions imposed or in terms of the time period within which the state of emergency should remain in place?
Are there
any limitations to that?
Time limits.
Or time limits?
Yes, Commissioner. Not. I think there are time limits set because, for instance, the state of emergency regulations should not be implemented for a lengthy period of time. For instance, if the reason that triggered the emergency has fallen away, it wouldn't be justified for the state of emergency to continue.
Thank you.
In reply to one of the preceding questions, Mr. Tembwe, you indicated that you spend 1 week a month on adjudication, whereas the rest of the month is dedicated to administration. Is that the case, and for how long a period has that been the case? And is it from 2007 since the appointment as divisional magistrate?
This only emanated from 2022 when I became a divisional. But before that, when I was still in the district, the time for sitting in court was full time every day.
So it is now full time. You're no longer 2 weeks or 1 week per month.
No, I'm saying before 2022, I was still in the district court. So the whole time from 2007 to 2022, I was full time in the court. When I became divisional, that is where I now had to be taking care of the regional court and also be a divisional at the same time.
And how long has that been the case, where your duties seems more assigned or skewed in favor of administration?
From 2022. Yes.
Okay. You've had an opportunity to adjudicate on circumstantial evidence when the state is challenged as far as the availability of direct evidence is concerned. How do you go about evaluating circumstantial evidence?
On circumstantial evidence, that is an aspect that one encounters when adjudicating in criminal matters. So the approach on circumstantial evidence is that if it's the only piece of evidence that the state are relying on, as a judicial officer, you can only convict if the evidence at hand draws the only conclusion. I mean, if the evidence, if you can draw conclusions from that, from the circumstances, and your conclusions are or let me put it like this. When faced with circumstances of circumstantial evidence, the court has to consider other surrounding circumstances, and if the only conclusion that the court can draw is that the accused indeed committed the offense, only then can a court convict an accused, where reliance was only based on circumstantial evidence.
Are you familiar with the locus classicus in the instance of circumstantial evidence, your main case in this area?
Leading case on circumstantial evidence.
Leading case on circumstantial evidence.
Applying it most on a routine basis.
I've read some judgments on circumstantial evidence.
So if you don't know, you don't know. You can just tell us.
I cannot cite one with certainty. But the principle, I'm very much aware of the principle, and I've applied it several times.
Often you adjudicate on a crime where you have a mandatory sentence applicable and prescribed. Sometimes it's a key to deviate from that by way of exception. What is it that you will take into account in the deviating from mandatory sentence as a presiding officer?
For instance, in rape matters, there are some minimum sentences. So the court can deviate from the minimum sentence if the cumulative effect of the sentence will be unjust to the accused. For instance, if an accused is charged with maybe 4 counts of rape and the minimum sentences is maybe 15 years on each, and then the cumulative effect draws the sentence maybe to 60 years or so.
Are you familiar with the concept of substantial and compelling circumstances?
Yes, Commissioner, I'm aware.
I think the Commissioner wants you to discuss that.
Substantial and compelling circumstances, usually the court is not allowed to easily deviate from the prescribed minimum sentences. In the matter of S versus Lopez. So the deviation from the prescribed minimum sentences is not something that just comes automatically, but it has to be justified. There has to be something peculiar in the accused mitigations that will entitle, a court to deviate from the prescribed minimum sentence. One of the instances I mentioned was situations whereby the cumulative effect of the sentence, if they are to be given their full effect, will be unjust to the accused. And then the other...
Even if it's mandatory?
Pardon?
Even if it's mandatory?
Yes, even if it's mandatory, a court may still deviate if there is presence of substantial and compelling circumstances present in the circumstances of the accused.
Yes. Commissioner Kamba, please, would you like to come in?
Thank you, Chief Justice. If you sit as a judge of appeal in an appeal against sentence only, and an accused person informs you on the day of the hearing that he also wishes to appeal against his conviction, how would you handle that situation?
Just repeat once more, Commissioner.
If you sit as a judge of appeal, you'll recall that in the High Court you will also be sitting on appeals, reviews, and so forth. You're not necessarily a court of first instance. So when you sit as a judge of appeal in the High Court in an appeal against sentence, but on the day of the hearing, an unrepresented accused informs you that he also wishes to appeal against his conviction.
You mean...
How would you handle the situation?
You mean his conviction in the High Court?
No, his conviction in the Magistrates' Court. You're sitting as a judge of appeal.
You remember when should you be appointed in the High Court, you also have to sit in the judgment of your former colleagues at the Magistrates' Court level, isn't it? Now, the question that you are being asked now relates to you performing your duties as a court of appeal in the High Court. Commissioner, would you like to go through the question again so that...
Of course, Chief Justice. So what is before you? You're sitting now as a judge of appeal in the High Court. So what is before you is an appeal against sentence. But on the day of the hearing, an unrepresented accused informs you that he now also wants to appeal his conviction.
Thank you, Commissioner. On that subject, if an appeal that is before me is based on, if the accused is appealing against the conviction, I am only bound to hear the appeal based on the ground that was arisen in the notice of appeal. I cannot automatically hear the appeal based on the recent averment that has been brought now by the accused person, because I have to adjudicate on that appeal based on the appeal that was filed. The issue of conviction cannot automatically be brought at a stage where the hearing is about to be held.
Okay, and when you consider now the appeal against sentence, when you read the record that accompanies the appeal from the lower court, if it appears to you that the conviction was incorrectly made in the lower court, do you have any power to address that situation?
Inherently, I have powers to address it.
And how would you go about it?
I will address it from the angle of me having become aware of that aspect while adjudicating the appeal based on the conviction, but not necessarily at the prompting of the accused person.
But remember, in the factual scenario that I gave you is that you're sitting on as a judge of appeal against sentence only. So before you is an appeal against sentence only. The accused person never noted an appeal whatsoever regarding his conviction. He appealed his sentence only. But when you read the record, it becomes clear to you as the judicial officer or the presiding officer that the conviction was also incorrectly made. Do you have any power to address that issue?
I have the power to address the issue.
And how would you go about it?
How do you go about it? And on what principle? If you can
recall. I cannot recall the specific principle, but I know that the Constitution allows me to address such issues, and also the High Court Act.
Very well. You're also familiar with Section 61 of the Criminal Procedure Act, in circumstances where bail is applied for in where persons are incarcerated for serious offences contained in Schedule 2. You're familiar with the section. That section requires a judicial officer to do an inquiry as it deems necessary. Can you explain to us what that entails? How is that bail inquiry conducted?
Maybe I'm not getting it clearly.
Section 61 of the Criminal Procedure Act says or provides that where an accused who is in custody in respect of an offence referred to in Schedule 2, where he applies for bail, then, or to be released on bail, then the court must, or the court can refuse the application for bail if, in the opinion of the court, after such inquiry as it deems necessary, and if it is in the interest of the public and the administration of justice, the court can then refuse bail, or only grant bail if it is of the view that it is in fact in the interest of justice and so forth. How? My question relates to the inquiry itself. It requires the presiding officer to conduct an inquiry. How should a presiding officer go about that inquiry?
Thank you, Commissioner. The inquiry will be in a form of, usually where Section 61 is invoked, it comes when there is a bail application, where both the state and the accused are afforded an opportunity to for instance, an accused is afforded an opportunity to address court or to lead evidence as to why he should be released on bail. And the state also is equally afforded an opportunity to present evidence as to why the accused should not be released on bail. And in that inquiry, there is a duty on there is a duty that is on. I mean, there is a duty on the side of the court to establish from the parties that, to establish whether number one, the accused is not a flight risk, and there is also reasons to establish that it will not be in the interests of the administration of justice for the accused to be released on bail. So it's not something that just happens automatic. The state and the accused has to be given an opportunity to make presentations to the court.
Yes, and after both parties, both the state and the representation for the accused have made representation and called their witnesses, does the presiding or would the presiding officer under those circumstances have the power to make further inquiries?
Yes.
Of its own motion? Can the court of its own motion
yes, in
make
the hearing,
further inquiries?
yes, the court can do that.
One of the requirements of that section is it provides specifically if it is in the interest of the public or the administration of justice. What do you understand under those two phrases? The interest of the public or the administration of justice?
If I heard you correctly, you are inviting me to describe what interest of justice means.
Yes, the Criminal Procedure Act, as you likely know, do not define those two or those phrases. There is no definition in the Section 1 of the Criminal Procedure Act. So, what do those phrases mean then?
You see, on that subject, there is no exhaustive list. The court has to make a finding as to what necessarily amounts to the interests of the administration of justice, and circumstances usually differ. So it is a duty of a court to make a finding on what necessarily amounts to the administration of justice, based on the circumstances that are before court.
Very well.
Yes. Thank you, Mr. Tembwe. Is there anything else that you would like to let the Commission know from your side? Not something that, that we've asked you?
No, Chief Justice.
No complaint has been lodged against you at the Magistrates Commission, to the best of your knowledge?
No, I have no complaint in the Magistrates Commission.
No complaint. Any financial interests that you may wish to disclose to the Commission?
No, Chief Justice. I do not. I do not have.
Nothing of a personal nature that you may wish to bring to the attention of the Commission? Of course, being personal, once it comes out in the public domain, it's no longer personal. Let me just put a caveat.
No, that I'm aware of.
Okay. Thank you. I wish to thank you for coming, but I wish to inform you that should you be appointed, you should make use of the facilities placed at your disposal to acquire property of your own. The Commission is not really in a position to provide housing. You might have read somewhere, somehow, where it says something that provision of housing has been mentioned, but I want to tell you now that we are not in a position to make that facility available. So you must make use of the other facilities that are placed at your disposal.
Noted, Chief Justice.
I'm saying that because I know you may be coming out from outside this region of commerce. If you don't have property of your own, you might have to find accommodation. I'm saying that on the assumption that you are appointed. And it's really not a promise.
Noted, Chief Justice.
Okay, very well. Thank you, and good luck.
Thanks.
Last but not the least, Mr. Mwiliima, Elvis Mwiliima. Yes. Very good. Please take your seat, Mr. Mwiliima. Thank you. And welcome to the Commission.
Thank you very much.
You know all the commissioners here. In the event that you may not know all of them, they have been identified. But we would like to know more about you. Could you please introduce yourself to us? Who is Elvis M. Mwiliima, and what does the M stand for?
Thank you very much, Chief Justice. My name is Elvis Mwiliima. I'm currently the Divisional Magistrate of the Oshagati Division. I joined the legal fraternity in 2010, having graduated from the University of Namibia. I joined the legal fraternity through the PG's office as a public prosecutor at Ondangwa Magistrates Court. There I prosecuted from 2010 July 11 up until 2013 March. In 2013 March, I joined the bench, the magistracy. I've been a magistrate since 2013 to date. I worked in Ocho as a junior magistrate. I was then moved to Otavi, still as a junior magistrate, and thereafter I was transferred to Grootfontein. I also worked there as a junior magistrate in 2016. In the same year, I was then promoted to senior magistrate in Mariental, where I spent close to 5 months. And thereafter, I was again promoted to principal magistrate, where I was relocated to Oshinene. In Oshinene, I also stayed for a few months, if not 5 months, roughly more or less. I was then transferred to the Windhoek Relief Department, where I spent close to 4 years, until 2021, May, when I was eventually appointed as a divisional magistrate of the Oshagati Division. And that is where I find myself, and that is who I am now, Chief Justice.
So you were appointed divisional magistrate which year again?
2021.
2021.
May.
Right.
That's in short who I am.
Very well. As a divisional magistrate, do you preside over cases in court?
Yes, Chief Justice, I preside over cases in the district court and also in the regional court.
How many cases or partly heard cases do you have in the regional court to start with?
In the regional court currently I have, if I'm not mistaken, I think I have 3.
3?
Yes.
At which stage are they, if you recall?
One is a defense case in Chumeb. The other one is still a state's case. The accused decided to apply for legal aid in the middle of proceedings. And
where, in which district is it?
In Oshakati, at the Regional Circuit Court of Oshakati.
Right.
The one with defense case is in Chumeb. And I think that is
Very
it.
well.
The rest I have maybe 2 or 3 in the district.
How many do you have in the district court?
So far I can say
Partly heard.
Not more than 4.
Not more than 4.
Yes.
So in total you have about 7.
Probably 7 years. Some of them I picked them after the application.
Right. Now, should you be appointed, how much time would you require to finalize your cases? And what is the time frame that you have set for yourself to finalize those cases? Not that to take up your appointment.
Most of those cases are almost at the tail end. For the one for Chumeb, I'm hoping that we finalize it when I go back in June. Then the one for Shakati, I understand a lawyer has been appointed and it is ready to proceed. So roughly 3 to 4 months.
3 to 4
it
months.
Will be. I will be able to dispose of those cases.
Very well. Very well. CJ, would you like to comment on questions?
Thanks, CJ. Mr. Mwiliima, the sentencing jurisdiction as a regional court magistrate is of course different from that as a district magistrate.
Yes, DCJ.
And if I understand you correctly, you have been effectively regional court magistrate since 2021.
Yes, DCJ.
So that means about 4 years.
Yes.
And during that period, you dealt with roughly how many cases?
DCJ, because I actually do regional court on ad hoc basis, because I'm an administrative head of the division. So I go into court when the judicial officer substantively recuses themselves on some matters. I can say so far I've dealt with, I think, 3 or 4.
So in effect, you have limited experience as a regional court magistrate compared to exercising your district court jurisdiction.
Yes, one can say so, because I've done few cases in the regional court compared to the cases that I did in the district. I can say that most of my life I've dealt with cases in the district. Regional court, I started dealing with those cases since 2021, but I can say I finalized quite a number of them in the regional court.
Understood you to say 3.
Yes. The one that I can remember.
That's the one you are referring to as quite a number of them.
The one that I can remember, DCJ.
Okay, no, I just wanted to clarify that first.
Yes.
Now, Mr. Mwiliima, can you explain to us the principles that we apply in recusal applications?
Thank you, DCJ. In a recusal application, the test for recusal is that of an apprehension of bias, which is an objective test, a perception from a reasonable apprehension of bias, which is based on a perception from a reasonable person, and should also be based on reasonable grounds. So that is basically the test for recusal. The question is, will the magistrate or the judicial officer be in a position to bring an impartial mind to bear in the adjudication of the trial or the matter that is brought before you? If that is if you feel that you will not be impartial in the adjudication of the issue of the matter that is brought before you, and one can recuse himself or themselves. But basically the test is based on a reasonable person's test, who is informed and who is relying also on reasonable grounds of apprehension of bias.
Explain to us what you understand by the doctrine of precedent, stare decisis.
Stare decisis is the doctrine that speaks of judicial hierarchy, that all decisions of superior courts are binding on the lower courts, and the lower courts are bound to follow the decisions of the higher court. That's my understanding of the doctrine of stare decisis.
Thank you, Mr. Mwiliima. In terms of our Constitution, the President enjoys certain immunities from civil and criminal proceedings. Now, under which circumstances can the President be sued in civil proceedings, and under which circumstances can the President be charged with criminal offenses?
Thank you very much, Commissioner. I think the starting point is that the President is immune, like you said, from criminal prosecution of actions that are taken in the course of his work as a President or the head of state. However, not necessarily that the President can be sued, but the government can be sued, and then if there are certain decisions that are taken that are injurious to maybe to the rights of the citizen or members of the public. That is the one instance that I can think of.
Are you familiar with any specific article in the Constitution that deals with this scenario that you have just described?
Currently now, CJ, I cannot think of any.
I can't remember.
Yeah. But in your understanding, can the President be sued under any circumstances?
But the immunity principle is that the President cannot be sued in his personal capacity. But for certain administrative decisions, I think an action can be brought, but through the government of the Republic of Namibia, not through the President himself.
Right. In terms of the Constitution, the President also enjoys certain powers even to make laws through regulations. Article 26 of the Constitution empowers the President to make regulations by proclamation, and those regulations can only be made if he or she deem it necessary to maintain law and order, to protect national security or public safety. Now, giving such wide-ranging powers that are given to the President, can the President also, would the President be entitled to suspend any laws or to suspend the rights and freedoms that are granted in terms of the Constitution? If so, under which circumstances or conditions?
Thank you very much for that question. The Constitution is the supreme law of the land, and all the decisions that are taken ought to be in conformity with the provision and consistent with the provisions of the Constitution. There are instances, however, where the President can, through proclamation, brings into the operation, for example, the issue of the state of emergency. That is a circumstance under which the President can actually bring in a regulation to actually regulate certain movements, but not to take away the rights, especially Chapter 3 fundamental rights. Those cannot be taken away, but they can be limited to a certain, the exercise thereof can be limited to a certain extent on the basis of maybe the looming security concerns An example that I can think of is what the situation that happened in 1999 during the treason, the secession attack on the government satellite. That is the situation that I can think of. One of the rights, for example, that can be limited through the President's proclamation is the right of movement, for example.
Thank you. Mr. Shikongo.
Good morning.
Morning.
When faced with an application in terms of Section 174, that's now at the end of the state case, what is it that the presiding officer must take into account?
Okay, the test for Section 174 is as follows. Section 174 provides that if at the close of the case for the prosecution, the court is of the opinion or is of the view that the state has actually not made out a case to warrant the accused person being placed on his defense, it's under such circumstances that then the court can invoke that section to discharge the accused person and to actually terminate the proceedings. But what are the considerations now? One of the considerations is, one, you look at the evidence that has been adduced so far. Is the state's case based on the evidence so poor such that no court acting carefully will actually convict the accused person if the accused person decides to remain silent? That is the test. The court will also have to look, for instance, on the evidence that is laid and also look at what has been adduced during cross-examination in the course of the trial by the accused or by the defense in the determination whether that there is sufficient evidence to warrant the accused to be placed on his defense or to be discharged. I can think of a number of authorities, for example, prior to 2000, if my memory serves me right, the test has always been that if at the close of state's case there is evidence, there is a possibility that the accused will supplement the state's case if he is placed in his defense, then that application should fail. But subsequent to the judgment, I think, of Leroux, the constitutional test now became that there is no way an accused should be placed on his defense under the hope that he will come and supplement the state's case and convict himself at the end of the day. So those are some of the considerations that one would have to take into account when determining whether or not to either discharge the accused or to place him on his defense. Of course, also having regard to the constitutional presumption of innocence and the fact that the accused has no duty to prove his innocence.
And when as a presiding officer you are confronted by what comes down to circumstantial evidence, that's now in the absence of any direct evidence from the state, how do you go about evaluating that circumstantial evidence to arrive at the verdict?
Circumstantial evidence, the authorities say, circumstantial evidence is actually evaluated through inferential reasoning. You apply the principle, I think, in Plascon-Evans rule, where you...
Plascon is something else. Plascon-Evans is something else, isn't it? It's motion proceeding.
Are you familiar with the leading case in circumstantial evidence?
Yes, I am familiar with one of the cases. State v. Sawala is one of the authorities where Liebenberg actually discussed the issue of inferential reasoning, where there is no direct evidence. The court will be allowed now to draw inference from the proven facts. There is also another authority of state v. Diplom, where you look at the facts that are established, whether or not from the evidence that is laid and the facts that are proven, there is one inference that can be drawn and not multiple inferences. But
amongst those three that you've just mentioned, which one is the leading case?
From the locus classicus case is the Blom judgment. That's the leading authority that I can think of right now.
Okay. there are circumstances under which you might need to deviate or find yourself compelled to deviate from mandatory sentence. In doing so, you'll be, that's what case law prescribes, have to consider compelling and substantial circumstances. What are those compelling and substantial circumstances that you take into account?
Compelling and substantial circumstances are those factors, not necessarily that they should be exceptional circumstances compared to the other normal factors that one ought to take into account. But authorities have always said, especially in cases of rape, that where the court has to deal with the issue of substantial and compelling circumstances, the court must look at the court must actually look at one can say maybe almost extraordinary factors. Although they may not be special, those that if you take them into account, you will then be in a position to deviate from the mandatory minimum sentence. I can just think of the number of authorities that have dealt with the Section 3 of the Combating of Rape Act, where the Marelise judgment, for example, laid the test for compelling and substantial factors, where they say these factors need not to be, special. One can take the normal personal factors that the court normally takes into account, and then after having done an evaluation, determine whether they are weighty such that they would warrant the court to deviate from the sentence that is prescribed by the legislature. But what is important is that the mandatory sentences should not be deviated from for flimsy reasons, but it should be factors that are weighty.
Thank you.
Thank you, Commissioner Shikongo. Commissioner Campbell.
Thank you, CJ. As if you were to be appointed as a judge of the High Court, you will obviously also sit as a judge of appeal against judgments of your former colleagues in the magistracy. So if you sit on as a judge of appeal in an appeal against sentence, under what circumstances can the High Court interfere with a sentence given by a magistrate's court or any lower court?
That is on appeal now. The High Court is entitled to interfere with the sentence of the lower court or the magistrate's court if the High Court is of the view that the magistrate did not exercise the sentencing discretion appropriately or correctly. That is one of the instances that the court can interfere. For example, the magistrate did not, or the judicial officer did not apply his mind to one of the factors that ought to have, given weight. The personal circumstances were not balanced with the seriousness of the offense and the interest of society. Or, for instance, where one factor was overemphasized, it is at the expense of the other. Because there is a need for a balancing exercise during sentencing. But if the magistrate does not take into account some of the important factors that he or she ought to have taken into account, then the court can then interfere with the sentence. Another aspect I can think of maybe if the sentence is not competent in law. For example, in case of maybe statutory ordained sentences. If, for example, the mandatory minimum sentence, the law says, if you find that there are no substantial and compelling circumstances that are existing, you should give, for example, a sentence of not less than 15 years. And the magistrate goes and gives a sentence of 10 years. That sentence will not be competent in law, and the High Court is entitled then to interfere with that sentence.
Very well. Under the same circumstances, you're also sitting as a judge of appeal in an appeal against sentence only. On the day of the hearing, an unrepresented accused informs you that he wishes to appeal against conviction also, in addition to only sentence, which is before you. How will you handle that situation?
Because now the matter is already set, the trial ought to proceed. But if the accused person informs the appeal court that he intended actually to appeal against the sentence, against the conviction as well, I should say that is a bit of a tricky situation for the appeal court. But at the end of the day, the justice dictates that the court should not close its doors to a litigant, especially if the litigant is a layperson. I would have to assess this, maybe let me quickly ask for clarity. This time the matter is now ready to be argued before the judge.
Yes.
Or it is not being argued.
It's on the day of the hearing.
It's before you now as we speak.
Council all dressed up.
That's a bit complicated, but if the matter is already ready for argument, and I would have to ask counsels, but this one is unrepresented, I'll have to ask the representative for the respondent, for example, for the state, to address me on the legality of the approach that a layperson, whether or not the court can allow a layperson who, for maybe one or the other reason, for lack of knowledge and understanding, had applied against the sentence, but now decides he wants to move an appeal against the conviction. But ordinarily, the court will have to proceed dealing with the issue of the appeal on sentence. But then the problem there will, once the appeal is ventilated and is finalized in the High Court, it can no longer come back to the High Court again. So the option that maybe that I will have to take into account there is to either stand the appeal down and grant the accused person an opportunity to amend his notice of appeal with an application for condonation, of course, explaining the reasons
What is
why.
the source of that power?
The source of that power is, one, the High Court has got inherent jurisdiction. The court can actually rely on one of the inherent jurisdictional powers, or the Constitution of the Republic of Namibia, and but there are only two. The court can only exercise, in such scenario, the source will be, the court can exercise its power in terms of the inherent jurisdiction, because the Criminal Procedure Act, the one that deals with the appeals, Section 316, also makes provisions for amendment to the notice of appeal. However, that's why I say this is a tricky situation, that the appeal is already ready for hearing. The only thing that one can do maybe is to have to postpone the hearing and allow the unrepresented litigants to deal with the notice.
As a judge is to resolve tricky situations.
That's precisely why.
Yes. So
it's not a walk in the park.
But at the end of the day, the constitutional right of an accused person to litigate his or her issues before the court is the paramount consideration of the court. So it would not be appropriate for the court to close its eyes and actually show the appellant the door, who, on the account of being a layperson, could not bring a substantive appeal on the conviction, even if he wanted to do so. So I will exercise my powers in terms of the inherent jurisdiction and also in terms of the High Court Act.
Very well. Can you just shortly explain what you understand under the term "in the interest of the public or the administration of justice," as contemplated in Section 61 of the Criminal Procedure Act? Just to remind you, that's the section dealing with an application for bail where an accused person is charged with a Schedule 2, the more serious offences. What do you understand under those phrases?
Thank you. My understanding of what is in the interest of the administration of justice, one, like you said, that section 61 of the Criminal Amendment Act says the court, when dealing with those cases that are scheduled offences, dealing with the issues of bail, the court may still refuse bail for the accused person, even if the traditional grounds for bail are satisfied. For example, even if the accused person is not a flight risk, he will not interfere with the investigation, but then the court finds that the offence is one that is serious in terms of that legislation, that the offense is one that raises public indignation, that warrant that the accused cannot be kept outside custody pending trial, then that provision says that bail should still be refused. However, the consideration thereof is one that has to do with the issue of value judgment, because the court then must take into account a number of other factors in and over and above the normal one that I referred to here, whether or not he is a flight risk or not. But whether releasing him on bail will maybe arouse public outcry, will then endanger, for example, even the safety of the accused himself, because the offense that he committed is one that has raised quite a serious concern to the public. Then the administration of justice in that regard will dictate that such person should not be granted bail but retained in custody, because the administration of justice will be jeopardized if, for example, such a person is granted bail.
Thank you, Mr. Mwiliima. Is there anything else that you would like to let the Commission know from your side? So you have heard from us, maybe you also feel there is something that you consider to be important that we should know as a Commission.
All I can say is that this was quite a short session. I expected it to take a bit longer, but there is nothing from me that I would say I need to bring to the attention of the Commission.
Right.
Nothing really.
Do you want some more questions? We have more questions if you want to engage us a little longer.
No, I have no problem.
Yeah, thank you. So no complaints have been lodged against you seriously now by the accused persons, as it often happens, or members of the public about the way you handle a case or a matter, to the best of your knowledge?
I'm not aware of any complaint
yes.
that maybe one of the public members raised against me or that is pending before the Magistrates Commission.
Yes.
I'm not aware of any such. I know that a few days ago, I think yesterday or the day before yesterday,
yes,
there was a letter that was forwarded to me from the Office of the Chief Magistrate, but that was not really a complaint against me. It had to do with the absence of the judicial officer from the court at the Wangwena district. And the member of the public was raising a concern that they are not happy that the magistrate was not at court at that time, and we need to respond to that. But so far, that is the only issue that I know. That
do you have any financial interest that you think the Commission should know that may have an impact on your work as a judge should you be appointed?
I do not have any financial interest. The only financial interest I have is only in my salary. I don't have any other external source of income.
Any interest to the Magistrates Commission?
No, I don't have any other outside source of income except...
No, you don't have to declare your salary because we know where it's coming from.
Yes, I don't have any other external source of income from external sources.
Thank you, Mr. Mwiliima, for coming.
Thank you very much.
Good luck.
All right.
Good job. Thank you. We now have come to the end of our proceedings today. The Commission will now adjourn to deliberate on the interviews or interactive session that we have had with the nominees. Thank you for listening to us. Thank you for watching, and also thank you for being here. That has brought us to the end of the proceedings. We now adjourn.